face and bouncing off parked cars in the parking lot as he's trying to drive off. Wouldn't that type of evidence in this case bring this within the purview of the Ashlock decision?
No, Your Honor, and for the specific reason that in the Ashlock case, the court explicitly stated that the circumstances were very sensitive in that case. It was an extremely close issue in that case of whether a reasonable inference could even be drawn at all of actual knowledge of visible intoxication. Here, the facts are certainly less permissible in drawing that inference than they were in Ashlock. The patron in Ashlock got up and started to walk across the room. She fell, and she had to sit there for several minutes, unable to get up whatsoever by herself. She had to wait until another man came and helped her to her feet, and even then she couldn't even walk out to her own car without being assisted.
Well, Mr. Hard's own testimony was he was very drunk. He couldn't remember anything he did after he fell off the stool.
Well, Your Honor, he did testify that he was very drunk. However, he was able to not only stumble quickly towards the whites as they were leaving. He did fall when he swung and threw himself off balance. However, he was able to immediately pick himself back up and continue all the way out into the parking lot to his own car without any assistance whatsoever. He simply was not as intoxicated as the patron was in Ashlock.
Mr. Walton, did I understand you to say a few minutes ago that the bartender has no responsibility after he served the patron his last drink?
Under the statute itself, Your Honor, the bartender only is going to be held liable, or his employer, the bar, if the bartender has actual knowledge of the patron's visible intoxication at the time the alcoholic beverage was furnished.
Does that make any sense at all? I mean, you're the bartender, you serve me, and I'm not visibly intoxicated at the time I take my last drink, but 45 minutes later, I'm falling down, I can't move, I'm clearly visibly intoxicated, and you're in a position to stop me from getting in my car and going off and killing somebody, and you have no legal responsibility to do so. What purpose on earth would a statute like that have?
Well, Your Honor, quite frankly, that is a situation to be left up to the legislature. In the absence of the legislature telling...
Why do you say that? Why do you say that I, as a judge of this court, have no moral responsibility to look out for the people who are responsible for me sitting on the bench than that?
Well, Your Honor, the duties of a bartender have here in the statute been explicitly defined. When the legislature takes upon itself to come out with an explicit definition of what the duties of a bartender are, then when the courts have construed this not to include the duty to then prevent intoxicated patrons from driving off.
Well, it sounds like you're saying that the judicial branch is subservient to the legislative branch. I thought under our constitutional order we were equal branches of government. Don't the 9 of us have the same responsibility to keep our wives and children safe from drunk drivers as the legislature does?
Well, Your Honor, the only way in which that duty could be imposed under this particular case was if the plaintiffs had alleged a common law duty under a negligence claim in their complaint. However, the plaintiff has only alleged the breach of a statutory duty here. That means that this court cannot then impose and analyze the issue of a common law negligence claim when the plaintiff has not alleged a breach of such a common law duty.
What do you think the legislative intent was here in enacting something that would seem to be so contrary to any intelligent analysis? I mean, we all know that it takes a while from the time we take the last drink for it to hit us. Even if we're not drinkers, we know that. And yet, under your analysis, you say what the legislature was doing here was saying that any liability is cut off the moment the last drink is served, no matter how subsequently intoxicated the person comes. What possibly could the legislature have in mind in passing a statute like that?
Well, Your Honor, if it would not have cut off liability at that point, the liability of bars and bartenders would come extremely close to being a strict liability standard without any fault on the part of a bartender serving someone whom he had no reason to believe was visibly intoxicated, and then to be held responsible for that patron's later actions comes too close to a strict liability standard.
Well, I submit this to you. Under your analysis, I could come into your bar and say, I would like you to line up in front of me 27 shots of whiskey. And then I proceed to consume all 27 of those and fall off the bar stool and roll out of there, and you have absolutely no responsibility under this statute, right?
Yes, Your Honor. However, there may be a responsibility under a common law negligence claim, which the plaintiff here has not alleged.
Thank you.
Thank you.
Now,
Mr. Walden.
didn't the Esperman case, though, say that the court could take into consideration the condition of the person shortly after leaving the tavern? Isn't that a consideration that the Indiana appellate courts say that the trial court can take into consideration?
Yes, Your Honor. It is one of the factors that a court can take into consideration.
So his actions as he left the tavern can be considered, correct?
Yes, Your Honor. In order to establish a reasonable inference of acts of visible intoxication that would have been occurring prior to that point. Here, however, we have positive evidence that neither John Daniels, the bartender, nor the plaintiff herself, who were both in a position to observe Hard, saw any signs of intoxication. We also have evidence that Hard was simply sitting at a bar stool and was not in a position where he could have demonstrated such signs of intoxication as impaired balance and stumbling and staggering around and things like that.
Mr. Walden, we've mentioned Jackson versus Gore, but if this case is compared to the facts in Jackson versus Gore, wouldn't that case compel us to deny the motion for summary judgment?
No, Your Honor.
Why not?
Well, there are several reasons, at least two. First is the activities of the patron in Jackson were substantially more significant than the activities of Edward Hard here. Here, Hard was simply sitting at a bar. And the patron...
Until they fell down.
Yes, sir. Yes, sir. And that was out of the observation of Mr. Daniels. So in order to support an inference of actual knowledge, only the evidence of what occurred in the presence of John Daniels may be considered. The waitress in Jackson was exchanging money with the patron, and the patron was up playing pool. As well, here we have no evidence that Hard was necessarily doing anything in the presence of Daniels other than simply raising a shot glass to his mouth, which simply would not have provided an adequate opportunity for someone who was casually observing him to know that the man was visibly drunk.
What's the purpose of the blood alcohol chart? Why would you even use that if it has no bearing on the facts in this case?
Well, the blood alcohol chart can certainly be used to establish constructive knowledge of intoxication under a common law claim. Here, however, where...
Doesn't the chart establish a legal standard?
The blood alcohol content chart, Your Honor? It indicates that the legal limit of blood alcohol content in Indiana is 0.08, but it provides no basis for inferring that someone who is intoxicated over the legal limit is necessarily visibly demonstrating that level of intoxication for someone who is observing the patron to have any actual knowledge of, Your Honor. I see that my time
What are you going
is...
to do with Ms. White's testimony, though, to the effect that when he came over to the, to congratulate them or something, that she could tell he had been drinking?
Yes, Your Honor. The only fact that she said was characteristic of Hard that was unusual was the fact that he was more chatty than he usually was. The Indiana Supreme Court in 1999 in the case of Delta Tau Delta explicitly held that where the only evidence of a patron's unusual behavior is that he is more talkative than usual, that is insufficient as a matter of law.
She said he seemed like he might have had a few drinks, and this was before he drank all of these others.
Yes, Your Honor. And the only evidence on which she was basing that inference was the fact that he was more chatty than usual. She said other than that, there were no other signs of intoxication. The Indiana Supreme Court explicitly said in Delta Tau Delta that where increased talkativeness is the only evidence, that is insufficient as a matter of law to support any reasonable inference of actual knowledge.
Mr. Chief Justice, we've had a red flag for about 5 minutes.
Well, I appreciate that, and Mr. Walton, we appreciate your letting us get all of our questions out. Any of my
He hadn't,
colleagues,
he hadn't made a single mistake in summation.
any of my colleagues have any last questions? Mr. Walton, you want to take a minute to sum up?
Yes, Your Honor. Thank you. The evidence here is insufficient to demonstrate that a reasonable inference may be made of actual knowledge of visible intoxication as required by the Dram Shop Act of Indiana. The Indiana Supreme Court has explicitly stated that, quote, where there is insufficient evidence to support actual knowledge, the issue may be resolved as a matter of law, end quote. Here, since there is insufficient evidence to support a reasonable inference of actual knowledge, this court should conclude as a matter of law that the plaintiff has failed to satisfy this essential element of her claim, and we ask that this court grant the defendant's motion for summary judgment. Thank you.
Thank you, Mr. Walton.
Thank you.
Thank you.
Mr. Van Meter?
Good afternoon, Your Honors, and may it please the Court. My name is Jordan Van Meter, and I, along with my co-counsel, Mr. Ben Walton, represent the defendant, Mr. Patrick Gibbs, and Standalone Properties, together as O'Malley's Tavern. Today I will argue that because Mr. Hart's intoxication was not the proximate cause of the injury, there is no genuine issue of material fact, and summary judgment is required as a matter of law. I'd like to reserve 2 minutes for rebuttal.
Very well. We'll try to keep track of that.
Your Honors, the facts of this case lead to one very simple conclusion. The plaintiff here was the victim of a crime, not negligence. Mr. Hart's intoxication was not the proximate cause of the injury in 2 ways. First, that Mr. Hart's criminal act, which is evidenced by his pre-existing criminal intent to cause harm to Mr. White, is a superseding intervening cause which breaks the causal connection between any negligence of the defendant and the injury, thus barring the plaintiff from recovery. And second, that because this was a criminal act, the injury which resulted was not the natural and probable consequence that was reasonably foreseeable in light of the intending circumstances.
Now, Mr. Van Meter, it would be helpful for me if you would start by defining proximate cause.
Yes, Your Honor. Proximate cause is essentially a cause that, if it according to the holding in Booker and Wells, but for the cause itself, the injury or result would not have happened. That's essentially the proximate cause definition as we understand it. Now, Your Honor,
Well, how's that different from just plain old regular cause?
Your Honor, when you're dealing with issues such as this, as where Mr. Hart obviously caused the accident, and the plaintiff is asserting that the bar who had nothing to do with the actual injury is liable.
Well, I'm just sort of interested at a general abstract level of understanding the difference between proximate cause and plain old regular cause. I mean, what does the adjective proximate add to cause if all proximate cause means is but for?
Yes, Judge Sullivan. The proximate also means near to or next to or proximate to, essentially. That while it wasn't the absolute direct cause, it was proximate to enough where the proximate cause of it could be responsible, as the plaintiffs assert in this case. Your Honors, a very simple observance of the chronological order of the sequences of events that took place from the beginning of this story until now only reasonably lead to one conclusion, and that is that this act was a criminal one by Mr. Hart.
Well, is that your test, that if the act is a criminal act, then there's no liability can be